Dear friends and colleagues, welcome. We have another session. We have here a lawyer. We would like to explore some of the inheritance law. And as usual, I would like to welcome Mr. Fawaz Maarouf, attorney at law, and let him introduce himself to our audience. Mr. Maarouf, please go ahead, introduce yourself.
Thank you. I'm Fawaz Maarouf. I'm an attorney at law licensed in Texas. Just a little bit about me. I specialize in Islamic inheritance law. I create Islamic wills and trusts for Muslims. And I also do estate planning in general, just for the general public as well. A little bit about me, my experience. I worked in the oil and gas industry for over 10 years prior to being an attorney and after being an attorney. I specialize in title research, basically reviewing deeds, judgments, decrees, and also a lot of wills and trusts to determine who the rightful heirs are. And that's kind of what brought me into estate planning, because I saw the importance of having a will or having a trust to make sure your assets are distributed accordingly to your wishes.
Oh, great. Will inheritance is very important topic for majority of us. Sometimes some of us little bit younger, they do not understand the value of it. That they try to procrastinate, saying that, oh, I don't need it right now. Maybe I will need it. I will need it later on. So, do I need a will? If somebody asks that question, what should be the answer?
That's a good question. A lot of people do ask me, what happens if I don't have a will? What happens when I die to my family? Can they distribute my estate how they want to? And they're just not sure. So it depends on different states. All I can speak to is the state of Texas. Each state has different laws. They're called intestacy laws. That means if you die without a will, you died intestate. The state determines who owns your property in what portions, and you do not. So they have a formula set out, and basically your family does not have immediate access to your assets. You have to go to court, they have to appoint an executor, and they have to distribute the assets. The court process could take up to 2 years for all this to happen, while the family is trying to figure out what assets you have, how to access your bank accounts, who has property to the house. The state determines everything. You lose control over that. So that's why I believe it's very important to spend a little time and invest in a will, for the reason you spend your whole life building your assets for your family. So you want to spend a little bit of time making sure it goes to them easily. They have access immediately, and you know exactly what's going to happen to your title of your property, of your cars, of your bank accounts. You know exactly where it's going to go at the time of your death.
Great, and that's very valuable information. We all need to know that. And thank you very much for providing us that information. Now, sometimes we see individuals write their own will, and they don't go to a lawyer or attorney. They draft, or there are some sample will files out there. They fill it up and take it to a notary, and keep it to different individuals. But the question is, do I need an attorney to make a will?
That's a very good question. So I would say yes, and you do not need an attorney, but I do advise that you get an attorney, and this is why. The will is a very complex legal document. Each of provision does something else. Each provision means something. So when you're drafting a will, you might not know how the provisions interact with each other if one contradicts the other. And every state has very specific and strict laws to make a valid will. In Texas, you have to have two witnesses that are 14 or over that are not beneficiaries of your will witness your signing. And you have to sign it in a specific way. And basically, if you take your chances and you try to do a will yourself and you miss one of these legal requirements, your will may be invalid. And basically, you died without a will. And then we have to go through the court process for your family. So it's always advisable to not roll the dice, invest a little bit in a will, and make sure it's done properly by an attorney.
Oh, great. So you mentioned age for an witness is 14. Normally, is that the case? Normally, we thought, it's a little bit more higher age than the 14.
Sure, in Texas, yes, you just do need two witnesses that are 14 or above to witness you signing the will. And another point is, in Texas, they allow self-proven affidavits. That's a separate sheet where you notarize it. So the will, in the future, you don't have to get the witnesses to appear in court to say, yes, I am the witness that signed it. So it's always good practice to get a notary as well, to get a self-proven affidavit with a will.
Oh, great. Thank you very much for that information. Okay, so naturally, another question we can ask is, beside the will, do I need anything other than a will?
That's a good question as well. Yes, I believe every estate plan should have a few components. One, of course, the main one is the will. The second one, you need a financial, or it's called a durable power of attorney. This power of attorney, you give power maybe to your wife, maybe to someone. If you become incapacitated while you're alive, let's say you don't have the capacity to go do financial transactions, you can't go to the bank, you're in the hospital and you can't do something, that person you appoint is able to access your assets, so there won't be any disturbance. And also, I believe you need to have the proper medical forms. You need a medical directive, medical power of attorney, so someone can make medical decisions on your behalf if you're incapacitated, and a HIPAA release. The HIPAA release will allow someone to get medical information if you're incapacitated, or to get status updates if you're in the hospital. So without these medical forms and the durable power of attorney, if you become incapacitated, your family will not have access to your assets when they need them the most. And another thing important is a guardianship declaration. If you have minor children or disabled children, let's say you have minor children, yourself and your spouse, God forbid, get in an accident at the same time, you appoint a guardian for their estate, for their financial reasons, and for the person, for the parental reasons as well.
Oh, great. So it looks like that the will anyone will be drafting, it has to address comprehensively all of the items you have mentioned. For example, durable power of attorney, medical power of attorney, HIPAA release, and guardianship. So it seems like in a general, if an individual try to write their own will or try to use a sample, a will from online, that might not cover all these issues holistically, right? That's why an individual might need assistance from an attorney or a structured will program which will address all of these issues. Is this
Yes,
the
that is a good point. So the financial power of attorney and the medical forms, these are legal documents aside from the will, but they should be part of the entire estate plan. The will appoint your executor, will state your burial rights. They'll describe what you want with your personal property, any donations, your real property, and anything else, what you want to do with your estate after your death. The financial power of attorney, the medical forms are during your life, but if you're incapacitated. And I do want to bring up another point. A lot of people come to me with, they need religious wills, like Islamic will, or for any religious reason. And that's another reason you do need an attorney for this, because of course, Islamic law is not recognized in Texas or in the United States. So you have to carefully draft it where you give the executor just enough power and flexibility where they can take care of the matters with minimal court supervision. So they can go ahead, distribute your estate, they can sell your property, and you have to have a specific schedule. Instead of saying this is an Islamic will, for instance, you have to have a specific schedule that shows who your heirs are and what portions.
Oh, great. Yeah. So inheritance law in Islam, it is explicitly mentioned in the Quran. And we know that there are some other religions as well in the Judaism and Christianity. They might have their own explicit, law for themselves. So it is a good idea for individual who wants to distribute their assets after their death, religious wise and also family wise, to take assistance from an attorney who knows entire process in and out. So that's what you are suggesting, right?
Exactly. And what I can speak to is the Islamic law, for instance. You do have to, in the Quran, it does make it an obligation to distribute your estate a certain manner. This is who gets how much of your estate. This is who is entitled to it. And basically, the will is going to outline this. basically saying you're going to pay your debts first, all the legal debts to comply with Texas law. And in addition, you can add a provision to include your Islamic debts, unpaid zakat, unperformed hajj. And then Islamically, you have a provision where up to 1/3 of your estate, you can give it to a charity or someone that is not legally entitled to your estate. And then the remainder will go just according to the Quran. And this is just Islam, but I know Judaism, Christianity, they have different rules or maybe different specificities. And you can include anything you'd like in the will. This is all your wishes, however you want your estate distributed.
Great. That's a very important information for all of us to know. And then also, sometimes individuals who just graduated, a bachelor degree or master's degree, got into workforce and or probably didn't married or, about to get married. We have seen there are some trends that among them, oh, that's probably something in my, bottom of the list. I'm not worried about right now to draft a will or, do something like that. What would be your advice for those individuals?
That's a very good point. There's a lot of people that come to me and they say, I want to wait maybe later. I'm too young. Maybe when I'm married, maybe when I have kids. And that's the mentality. Unfortunately, we just do not know when our time is going to come, when you're going to pass away. And it's going to be the same result, whether it's your wife and children dealing with the court process and trying to figure out how to get at your assets at a time they should be grieving. It's the same with them. They have families, they have mom, they have dad, and they want to access their estate, and they don't want to deal with the court process. They want to deal with grief. They don't want to deal with that process. So I would say just do it for your family. Just make it easy on your family and distribute your assets that you worked hard for in a manner that you want. You want to be in control of who gets it and who's in control of your estate at the end of the day.
Great. And also, since we are in Texas, Texas is a community states out of, many community states, and, husband and wife get certain portion, of the asset. For that sense, sometimes I hear from some individual, it's like, when I am not here, my wife is going to get everything. And sometimes when an individual purchase a big investment like a house or big business, they title is such a way that both husband and wife, especially for a primary residence, they have to, their name needs to be there or some kind of laws that protects them, so both husband and wives become the owner of the property. So for that sense, when individual gain additional properties, do you think their title has to be uh, drafted certain different way for will purpose?
Well, that's a good question. So to go to your point, yes, Texas is a community property state. That means any income you make or your spouse makes or anything you purchase together while married, unless you prove it with clear and convincing evidence that it's your separate property, it's your own funds that you paid with it, everything is going to be owned half and half. Even if your wife or your husband is not on the title, your car, your income, your house, it's going to be owned half and half. And that's a really good reason why each person needs their own will. Because if you only have your own will and your spouse owns the other half, you're only conveying one half interest. You're not conveying the full amount. So whenever you do get more properties and you want to, you want to make sure that they're conveyed in a certain manner, there's a few things you can do. You can list them out in the will and you can specify exactly who's going to receive it, knowing that both of you own half and half, or you can have a deed as joint tenants with right of survivorship. All that's saying is when one spouse passes away, the other spouse automatically gets a title to the property without probate process, without anything else. And this works vice versa. So whoever's joint tenants, whenever one passes away, the other will inherit 100%. So those are your two options. In your third option, you can always put it in a trust if you have a lot of rental properties, if you have a lot of investments. A revocable living trust is also a good option.
Oh, that's another very important information. All of us should know that. And then I have also observed some individuals who wrote their will, and after that, during 2, 3, 4 years later, their, status change, their, procurement of other assets or lifestyle or, other life job related 401k or other, asset information change. So how often do individuals need to amend their wills or like, make changes to the will so that it addresses everything?
I'm glad you brought that up. We try to make wills, attorneys in general, where they'll last a really long time. You specify kids in the will, and then you specify any future born children. So that said, you can keep your will as is. There's a few scenarios where you need to amend it. If you made your will and you did not have any children and you did not account for them, and later you have a newborn child, now you're a father or you're a mother, you do want to maybe amend your will. Another situation is if you're married to someone and they're in the will and you get a divorce, you do want to amend the will. Any big life changes such as that, you want to consult your attorney and say, is my will okay as is right now, or is it time to amend it? And that's what I would suggest, just in big life-changing situations.
Oh, great. That's very important information for us to know. So it was really a pleasure to have you, Mr. Fawaz Maarouf, and I wish you all the best in all of your, endeavors in your life. And any last word for our viewers from you?
No, I appreciate the time and I appreciate your program. And I hope everyone thinks about their estate plan and talks to an attorney for one.
Okay. Thank you. Have a good day, sir. God bless
You
you.
too. Thank you.
Bye bye.